Ms. Rotunno, thanks so much for taking the time. I appreciate it.
You're welcome. Nice to see you.
You are not a full-time member of the bar here in New York, as I am, for example. But there was a period of time where you were the most famous lawyer in New York. Tell me what it's like to try a case in New York. How is New York different? How are the courts here different? What was your experience?
Sure. So I try cases all over the country. My main place of business is Chicago. So I do the majority of my work in Chicago. So Cook County is the second largest prosecutor's office to Los Angeles. So I am used to large systems. So coming to New York was really not a big deal. Somebody who's tried cases in very, very small jurisdictions to very large ones. I'm comfortable in a courtroom. And so I would say for the most part, everything about what we did there is very similar to what I do anywhere. I think what was most unique about trying a case in New York was the judge that we had on that case was not retained and did not remain on the bench after the Weinstein trial. So that was unusual because no matter what it seems that you do in your government positions, you maintain and retain your employment. So I was encouraged to see that his bad work, frankly, did not mean that he retained that job forever. So that was encouraging.
I did want to ask you about the reversal that came down a little while ago. Were you surprised given the statistical rarity of appellate reversals in general?
Sure. I mean, it is so rare for an appellate court to overturn or reverse jury verdicts. And really, I was surprised that they had the guts to do it. I'm grateful that they did. From the legal lens, I think it was the right decision. So it was encouraging to me that the legal lens won and justice prevailed in the sense that we have laws, we should apply those laws. Those laws should not be stretched. And I really did agree, and I had said from the very beginning that the really interesting part about the case was that it was almost as if it felt that it was this prosecute and win at all costs. It really never felt as if there was really a true seeking of justice. And I argued that in my closing argument in the trial. It felt like there was so much pressure on that government table of lawyers to obtain a conviction more than it was to seek what was really just. And was it just to allow all those people to testify? Was Harvey able to get a fair trial? And so I was encouraged by the decision because I think it showed that the justices were able to put aside the emotion of it all, put aside things that really are not, shouldn't be evidence and make a decision. So I was very encouraged.
How should courts deal with what they call here in New York malo evidence? They call it different things in different places, right?
Yes.
What we're talking about is prior bad act evidence, right? Most folks that go to trial here in New York and obviously in many other places have a history of something, and it's the prosecutor's job to push as much of that stuff into the trial. It's the defense lawyer's job to keep as much of it out, and the judge will ultimately make a determination balancing the interests of both parties to some degree. How should courts do that in a way that doesn't prejudice the defendant in unduly, let's say?
Well, I think in this case, it was clear that it did. And there are laws and rules, as you said, in New York, it's the malo evidence. And in those cases, bringing in evidence to show that someone had a propensity to commit a crime is not allowed. And it shouldn't be allowed in any form. And I think that in this matter, the justices felt that really the only reason to bring this in was if he did it before, he must have done it again. And so that's not what the law is intended to do. The law is intended to bring in that evidence if it would help a jury make a determination based on identity, based on a variety of other factors. This obviously wasn't an identity circumstance. It wasn't because this person had done these things in this way before, it must mean that it was him. That wasn't the situation. Everybody knew who he was. There was no identity issue. There was no common scheme or plan, modus operandi, things of design. The real purpose of bringing this in was really to show the propensity to commit the crime, and that is not allowed under the law. So, now there's this big push, I know, in New York and in other states to change these laws, but the laws really are already in place. The issue really comes down to propensity, and people don't, they want to take that part away too now and say that you should be able to bring things in to show propensity. And I think that would be a grave disservice, especially when we're talking about uncharged crimes that had not been vetted in any other way, crimes that had not been, had gone through the judicial system before, where people were cross-examined and asked questions and held up to the scrutiny of an investigation or even a detective questioning them, for that matter. So I do think that it opens up a huge can of worms, and I hope that doesn't happen in New York.
The relationship between a criminal trial and the media has been contentious for decades, ever since the 60s, probably. In this particular case, I remember I was at that courthouse at some point, and I had a defendant on that was a well-known defendant. Typically, you would have reporters there. For my case, it wasn't even close, right? I couldn't get near the courthouse on those days. How should courts deal with the media, right? Obviously, there's a constitutional protection for the press that we have here. We should have it. We likely agree, as everybody should agree, that a free press is a good thing. How do we keep a free press from impacting negatively the defendant, the jury, things of that nature?
Well, I would agree with you that a free press is a good thing, but I think that we need to also make that a fair press. We don't have press anymore that just report the news. They don't call balls and strikes. They don't tell us what's happening. Everything has a slant. Everything has I think a modicum of opinion writing. And I think that that's scary. And, even in headlines, right? We live in a world now where all people really do are read the headlines, and they don't, once you read the article, you normally think, oh God, that headline was misleading. And so I think that we're in this, clickbait, social media, cell phone society where we're scanning through, we see something and we think we know everything about what's happening in the world. So as much as I think a free press is very important, that press also needs to be fair. And the problem is when you have a client who is the subject of so much media scrutiny, if it's not fair, how do you then pick a fair jury? And I had said this all along. There were never fair articles written about Harvey Weinstein, and the media quite often conflated civil cases and criminal cases. So in the criminal case in New York, there were 2 charged complainants, 2. But all you would ever hear is that 100 women were, accusing Harvey Weinstein, and people did not understand the distinction between, discussing multiple people filing civil lawsuits and those that were actually a part of the criminal case. And that was a big fight I would have with the press all the time. Or, the press would write stories. And quite often in my career, I've really tried to stay away from the press and the media and keep stories out of the media if we can. Now, in a case like this, of course, they're writing about it whether we comment or not. So there was almost, I felt on my part, that there was an obligation to comment because they were so one-sided that if we didn't, then the only thing out there were these unsided pieces. And I would say things to journalists, straight from my mouth, and I would say, here's information, here's facts, and they would say, there's no appetite for that right now. And that would be the response I would get. And how frightening is that? It's like, here's things that you could very easily verify. Here are things that are true. These are things that are going to come out in a criminal courtroom. And the response from the New York Times or the New York Post is, there's no appetite for that. That's pretty scary.
Traditionally, there are mechanisms to deal with heavy media attention in a case, right? You could ask for the jury to be sequestered. You could ask for a change of venue. You could ask for a bench trial. In this particular case, and in cases in general these days, are those solutions practical solutions?
I don't think they are. We did ask for a change of venue in Weinstein, of course, because there was not one New Yorker, not one, during the 3-week jury selection. Look, they selected a Trump jury, and in a couple of days. It took us 3 full weeks to select a jury in Weinstein. There was not one human being that was questioned of the thousands that did not know or hear about this. Not one. I mean, that is unheard of. I mean, you can walk out onto the street and ask 50 people who the vice president of the United States is, and 15 of them don't know. So the fact that there was not one human being on planet Earth at this jury selection that did not know about him or the case really tells you something there. And what the judge did rule during the change of venue hearing and our request for change of venue was that even if you move this case to, Idaho, everybody knows who Harvey Weinstein is. So what do you really accomplish by doing that? So those solutions may be practical for some defendants, but I think for others, you're just so big that it's not going to make a difference. Especially when in this case, there were 187 press credentials handed out that were worldwide.
Should cameras in the courtroom be allowed always, never, somewhere in the middle?
I don't really have a problem with it, frankly. I know in New York, it was a request basis and, victims can weigh in and on those things. So there were not cameras in the courtroom on the Weinstein trial. I think that in some ways it's, in the world that we live in where everything is available to us anyway. And, whether you watched it in court in person or, later court TV was doing readings of our voices at night, reiterating what happened. I mean, at some point people are going to find out. So frankly, if we're going to do it, I'd rather do it all the way than halfway and, let somebody hear my own voice rather than somebody reading a transcript of me talking. So if you're going to do it, I feel like it's an all or nothing, really, in my opinion.
You were caught up knowingly or unknowingly in this whole Me Too movement. And the Me Too movement, like we spoke a second ago about the press, is a good thing. Most people would agree on balance, right? To the extent that it helps women and marginalized people in their work and in corporate America and business, so on and so forth. There seems to be a difficulty when some of that pushes against kind of the fundamental principles that we've built this country on, right? Presumption of innocence and trial by jury, due process. In your work, in this case, in your work in other cases of this nature, how have you seen that dynamic, that inconsistency, if it is an inconsistency?
Well, I have to say, I would disagree with you in the sense that I don't think that these things are so great, frankly. And the reason I don't think that they're so great is because they remove the ability for someone to defend themselves. So yes, should people feel empowered to come out if something was wrong, they were wronged or something was done to them that was wrong? Sure, of course. But I feel like that is an old construct. And I feel like the world we live in today, it has changed so much, even in the last few years. I really think that we live in a world now where women have all the power in this situation. So when we talk about the power dynamic, I just don't believe it exists in the way that it used to. And frankly, we talk about the power dynamic and I hear women who say, I was forced to sign an NDA. No, you were not forced to sign an NDA. You had your own legal representation sitting next to you at a table, discussing with you all of your options. You made a decision to sign an NDA. And when you did that, a check was slid across the table back to you. So this notion that you were forced or you didn't have any other right or any other decision or you couldn't go to the police is nonsense, because you have your own lawyer that's sitting there with you and you've made a decision that you think is right for you, which you should be able to do. Make whatever decision you think is great for you, but then don't later complain that someone forced you to do something and now you're a victim again. I don't subscribe to that. In terms of movements, I think the problem with these movements is it does not afford due process. It does not allow someone to defend themselves. Somebody can come out on X or Twitter or social media and post something that someone did something bad to them. They can say their name. How does that person defend themselves? It's almost as if you don't get charged with a crime or you're not sued in court and somebody just makes this, hashtag Me Too claim against you. And now what is your recourse? You're fired from your job. You potentially are canceled, for lack of a better term. And now what? So, do I think that, women coming forward and talking about what happened to them is their right? I do, but I don't think that when it affects someone's ability to live their life, make a living without any other course of response um, or due process is fair in any way, shape, or form.
How has your life changed after this case?
My life has not really changed that much. Obviously, I mean, I've been a trial lawyer for 24 years. I still try cases on a regular basis. I tried one yesterday. I my life has changed only in the sense that people now come to me to ask my opinion about things I already knew about. So, in that sense, I'm more known. But in terms of my own life, I've made the decision that I didn't want my life to change. I liked how it was before, and I like how it is now. And I'm okay with being the face of this topic. It doesn't bother me. I really do think that I was the right person for the job and the right person to do it. And obviously, this reversal reinforces that for me. Yeah, my day-to-day Chicago life, I am still head of my firm here. I'm still auntie to my niece and nephew. I have 14 godchildren, and so the rest of my life is exactly how it was before.
All this Weinstein stuff is kind of an extension of what criminal defense lawyers go through every day, because there's such a negative connotation that comes with this. And I'm asked all the time, I'm sure you are, how do you defend people are guilty, and so on and so forth. How difficult is it to be a criminal defense lawyer in general society, not in the legal community, obviously, but in general society?
You always get asked that question. That's the question. How do you defend? My favorite is, how do you defend those people? That's my favorite. And I always think to myself, those people. And I asked someone at a dinner party once, and it was a woman who has a husband with some means, and of course she doesn't have what I call a job. And we are at this dinner. I don't know her very well, and she brings this up, and I said to her, well, I'm sure Kenneth Lay from Enron, I'm sure his wife never thought he was going to need a criminal defense attorney. And I'm sure, so it does touch all areas of life, all socioeconomic levels, all races. And so, people have this notion that you defend quote unquote criminals and they all look the same. And that's not true at all. And so I always try to remind people of that. I was actually having dinner during jury selection, of Harvey's jury selection, and I was in Manhattan having dinner, and I ran into some of the Real Housewives of the show, and one of them was very critical of my representation, and very rude. And my response was, I sure hope nobody in your family ever needs somebody like me ever. So it's very easy to cast stones. And I also try to remind people that my function in the system is to keep the system accountable. What we do really is the last line of defense against an overzealous prosecution, against a government who's out to get you. And how appropriate is that now? Whether you like or dislike Trump, anybody that looks at what's going on there has to, if they can take the emotion out of it for 5 minutes, has to be able to say, wait a minute. Why this case, especially the New York one, why this guy, why are they doing this? And so criminal defense attorneys are the last line of defense against those types of things. And so, you can say all day long, you may not like the person standing next to you, but it's no different than the doctor who's operating on the, Boston bomber, right? I mean, they have the job to do and they're going to do it. And that's how I feel. We have a system that we need to keep accountable. I'll continue to do that. And you may not like, and I've said it in my interviews about Weinstein, you may not like the fact that the court overturned the decision, but you have to look at the reason that they did it. And you have to realize it had nothing to do with the victim's claims. It had nothing to do with the veracity, the truth, any of it. It has to do with whether or not the process itself was fair. And so it becomes much bigger. It's bigger than Harvey Weinstein. It's bigger than any of these women and their claims. And people don't want to look at it that way, but they need to, because being unfair to him means being unfair to everyone.
Right. The argument from folks was that this reversal reinforces the power dynamic, right? The whole point of the Me Too movement is that there was a power dynamic in place that would prevent folks in power with money, with authority, to be held accountable. Do you see that as having happened as a result of the reversal?
Not at all. Not at all. This reversal has nothing to do with any of that. This reversal, I loved reading the comments about, oh, people with money can afford good lawyers. It has nothing to do with that. This had to do with whether or not the process itself was fair. That was it. Nothing more, nothing less. It had nothing to do with power dynamic. None of that is up for, for decision. That is a emotional reaction to a decision and having really no clue what the decision really says. The decision has nothing to do with any of that.
Do you anticipate that he'll be retried?
They say they're going to. I'm very skeptical. The reason I'm skeptical is in the original trial there was 5 counts. 3 he was found not guilty of, and then there were 2 left. One of those counts he has already spent all the time in that he could spend, so he's been maxed out on that count. The second count is one of the complaining witnesses in the case, and she had testified that she was not suing him civilly, that she had no plans to sue him civilly, and then did after the criminal trial, and received funds for doing so. And so I think that opens up her cross-examination in a little bit of a different way. And I don't know if she's willing to come forward. Last we heard, it was unsure. So, I'm just not so sure. I mean, maybe it works itself out. I don't know. I'm just not so sure. At this point, I reserve judgment as to whether or not that retrial will happen.
Do you find it harder to try cases in the sense that evidence and the prosecution's investigatory power in terms of electronic evidence, the internet, tools that bring about information that in years and decades past wouldn't have come about? Is technology making it harder to defend cases in court, in your opinion?
I think in some ways it's, sure, sometimes it can make it harder because, let's say that there's a body camera or a pod camera or something in the sky that shows us, or somebody goes into a hotel and you see something in a hallway. So from those ways, I think it can make it harder. But in many ways, I think it makes it better for us. I think it gives us information as to what's truly in the minds of people after they claim something terrible happened to them. Text communications, the way they act after. I mean, look at Trevor Bauer. Trevor Bauer was the athlete pitcher for the Dodgers, and Trevor Bauer was implicated. A woman claimed that she was sexually assaulted by him, that he choked her, that he did all these things. The police never filed charges, but Trevor Bauer had a $51 million contract with the Dodgers. The Dodgers let him go. He's now pitching in Japan, and there was an order of protection hearing, and then she sued him civilly. There were never any criminal charges. She sued him civilly, and in the civil discovery through her phones, it came out that she set the whole thing up, that she told her friends that he had this contract, that she was trying to get to the money, that she was going to act like a whore and get him to choke her out. And all of this came out. So here's a guy who loses his job. And, when you're an athlete, you have a shelf life of time to make the money that you're going to make, and how long is your arm good, and how long. And so here's a guy who lost everything in his life based on an allegation that was untrue. So when people say to me, how do you do what you do? I love to use those examples.
Why did you choose criminal law trial work?
So I chose criminal law because I love trial work. So that I sort of backed into criminal law. It was I walked into law school thinking I would never do family law and I would never do criminal, and here I am. So I started my career at the Cook County Prosecutor's Office. So I was on the other side. I worked there as a clerk for about 2.5 years during law school, and then 3 years as a lawyer, and left and went to the defense side. So for me, I backed into the criminal work because I love to be in a courtroom, but I do. And now that I'm doing it, I love it. I knew I was not long for the prosecutor's office. I enjoyed my time there. It was a great place to learn, but I needed to do what I'm doing now.
What does it take to be a good trial lawyer?
Tenacity, hard work, a really good memory helps me. I'm very blessed that I have a great memory. So my preparation can be cut in half from other lawyers I know because I'm just quick to memorize and remember. So that's good. I also think that you have to have the ability to not only see the big picture, but you have to have the ability to communicate to people who are not normally exposed to this system, how it works, and why. I always say my job is to get 12 people to see it my way. And the best way to do that is talk to them the way I would if I was sitting having dinner with friends, or sitting at a social event and explaining what I do to people. That's the best way to do it. So I think being um, uh, you have to be smart about what you're doing. I also think that you have to, I never want to throw everything at the wall and see what sticks. I think to be a good trial lawyer, you need to really identify the key issues. I think another really important thing that you have to do is you have to take water into the boat. So when the case is not potentially great on some fronts, you need to own those things. I always say never want to try to sell to a jury that the world is flat, because if you do that, they're not going to believe anything else you say. So, you really have to gain and earn credibility. But I think before you even get to those points, the part of being a really great trial lawyer is really doing the work, the investigation, things like getting all the evidence you can. They're not going to just hand over cell phones, right? You have to file motions to say that, these are pieces of evidence you think you are entitled to. And so getting there is important. And having done this now for as long as I have, and seeing, even now you learn, right? You find something new that you think, oh gosh, that's something I never would have thought to try to obtain. And so there's so much that goes into it, but I love the work. So
I've heard lawyers say that you can't try cases these days on reasonable doubt, which is how most criminal defense lawyers try cases. You have to try it on actual innocence. Is that something that you've seen, or is that a kind of distinction without a difference?
I think that sometimes that is true. I think there are some cases where no matter what you do, jurors want to hear from the defendant. They just do. And no matter how many times you say, the rules do not allow you to take that into consideration, I think that especially in sexual assault cases, jurors think if they were accused of this and they didn't do it, they'd want to scream it from the rooftops. And I think these cases, sexual assault cases, are different. I think that they're nuanced. It's different in a murder case. The jury doesn't care so much if they hear from the guy that they said pulled the trigger. They look at the evidence, and there's less emotion that goes into it. Normally, there's less knowledge and less familiarity between the parties. And so, I think in many cases, they just do. They want to hear from the defendant. So if I can, and if I think it's appropriate in the case, I usually will put a defendant on, especially in a he said, she said, especially in a circumstance where they know each other. And that was the other problem in Weinstein. And the court talked about that as well in the Sandoval ruling, saying that they wanted to bring in these bad acts of, things that Harvey Weinstein did, having nothing to do with these women and nothing to do with sexual assault cases, just, being a bad boss and throwing a stapler at somebody's head, doing all these things. And the judges said that given the Sandoval ruling, no person in their right mind would have taken the witness stand. And so there you put him in a position where he can't even defend himself.
I actually remember reading that you told the jury that it's important to distinguish between bad behavior, improper behavior, objectionable behavior, and criminal behavior. That's an argument I presume you make all the time. How important is it to make that kind of argument?
I think it's important, and depending on the case, but in these situations, yes, because especially if you think that you have a client who may not be likable to the jury, you want to talk about that very often. And especially in Weinstein, I talked about the difference between sins and crimes. Nobody was going to get up and say that Harvey Weinstein never did a bad thing in his whole life, right? I mean, even if he at least cheated on his wife a gazillion times, right? So you had to be able to address those things. And so, being a sinner is different than being a criminal. And there's a lot of real estate between the two. And so, I think that's another thing. Like somebody can be, and this was my other problem with the case. He was so hated by the prosecution, by the court, by the system, by the media, that it was this desire. I think that they were clouded by the hate and came after him in such a way that even their judgment was clouded because they hated him to such a degree. It was like, well, you still have the moral and an ethical obligation to give this man a fair trial, but it was just this desire to come after him at all counts. And my favorite argument is when everybody says, well, you know, people with a lot of money can hire good lawyers. It's like, well, but wait, people with a lot of money, they come after you even harder. Like they're not coming after the average guy with all those resources the way they came after him. You know, it just, you know, most sexual assault trials don't last 2.5 months. So, you know, it's just an interesting dynamic. And so there's always a plus and a minus column. Everybody always wants to talk about, you know, all the positives. Well, there's negatives too.
Why are good criminal defense lawyers important?
As I said, I think we are the last line of defense in this system. I do. I think that our job is to stand up before a court and keep everyone accountable. And if we lose that, what's the point of the system, right? If just by charging someone they're guilty, then what's the point of what we're doing? And I think our job is to maintain that fairness. That's what we're supposed to do. We're supposed to say we have a system that is built on this foundation of proof beyond a reasonable doubt, right to remain silent, due process. And if we're not the ones screaming it from the rooftops, who is? We know the prosecutors aren't.
Ms. Rotunno, I appreciate your time. Thank you so much for agreeing to do this.
Of course, it was great to talk to you.
Thank you.
Have a good one.